I'll make it short. I understand lunch is waiting for all of us. That was a very nice presentation from Richard. Every jurisdiction has opportunities and challenges. India, I'm from India. My name is Kirit Javali. Run my own law firm, Jafa Javali. I'm based in New Delhi. We are into company, commercial, and intellectual property practice. India is a land of several opportunities. It provides a lot of challenges as well. There's been a lot of buzz in the last 15, 20 years about the market, and foreign investment is growing a lot in the Indian market. There is comparison to China, and I'll primarily focus on the Indian market and the opportunities. There are also a lot of criticisms that the IP system is not very strong in the Indian market. However, the government has taken a lot of steps in the recent past. There's a new national intellectual property policy which aims at spreading awareness, creating opportunities, streamlining the administrative mechanisms, ensuring that proper enforcement and adjudication systems are in place. A lot has already been done. The legislations are in place. India is a member of WTO, so most of it is TRIPS compliant. The policy is in line with the Make in India and Digital India campaign, which the new government has undertaken. We have robust laws in place, and the courts are pretty pro-IP, especially in relation to foreign companies. So what should a foreign investor worry about when coming to the Indian market? It should conduct a thorough due diligence before coming to the Indian market. Especially, it varies from sector to sector. If you have certain retail products, you should do a thorough study of the country, because India is vast. It's geographically very different in different parts. There's also a cultural issue, the languages, a lot of number of languages. If you want to tie up and have a partner, it's best that you have the agreements in place, or else you just license it to the company. Alternatively, you also ensure that all your registrations are taken care of well in advance before you enter the Indian market. You must tie up with a good local team. Also, you must also have a good investigator time to time to study various sectors and markets and where things are going all along. The courts in India have been very proactive. It does give a lot of protection to foreign companies, even if they're not present in the country. There's something known as the concept of transnational reputation. The courts have been pretty protective about that, even if they're not present. Recently, they've also permitted cross-examination of foreign witnesses through video conferencing, which was not there earlier, which used to slow down the process, and as a result of which now a lot of things are moving faster. Contempt was a big issue where the courts have come down quite hard on the defendants who used to defy the court orders and escape the process. Now, it comes to a point where if there is a IP piracy in relation to computer software, the entire unit can be closed, and the defendant basically comes down to the court and basically settles the matter, and does not prolong his issue on the contempt. E-commerce is a big buzz in India at the moment. It's a huge market. A lot of startups have come in, and a lot of issues, a lot of sale of goods and retailing and logistics issues are involved. The challenge is where physically to locate the goods, where do you institute the proceedings. Jurisdiction is a big issue. Then we have other issues like domain names, distribution of content, and Richard talked about smart wars. The new thing is about apps on mobiles. It's a new phenomena, how to protect the IP on the apps in your mobile platform more than your websites. That's the new buzz. How do you go about whether do you go after the creator of the software or the owner of the app? These are all challenging issues. There was also a criticism that not much damages are awarded in Indian courts. The courts are finally realizing that needs to be taken care of. More recently, $150,000, which may not be very high in terms of European or US courts, but more and more courts are beginning to award higher level of damages. Primarily, the advice given to foreign companies are basically to ensure that you get interim relief by way of an ex parte order, which is what we always advise, because it might take years to get damages awarded. So in the interim, we always advise clients to get an interim relief. Many a times, we request the parties to settle the matter, and most of these infringements is by small-time players who are producing their own stuff. So we try and absorb them and make them a distributor of the eventual company. Enforcement is always a challenge. The important thing is to identify the violation, collect materials. Owner must have a private investigator. We must do a thorough market search and an internet search. Ascertain the jurisdiction where to file the proceedings, either the defendants where they reside or where the plaintiffs are conducting the business. Then you serve a cease and desist notice, and eventually you can also consider criminal proceedings, which sometimes works in the Indian jurisdiction to basically as a pressure tactic to ring fence the violator. Courts have been pretty proactive. They do grant ex parte orders, as you call it, the Anton Pillar order and the Mareva injunction. And the customs agencies have been sanitized. They do take the necessary steps to when import of infringing goods are brought about. Generally, there's a lot of opportunity, but like any other market, we need to take steps and ensure that a thorough homework is done. Generally, that's what I have really to say. Any questions I am ready to take on.
Thank you, Kirit.
Thank you.
So thank you to both of you for the interesting presentation. Before we open the Q&A session, I had one question for each of you, starting from Richard. So I appreciate what you're saying, that it's fortunate that we have the same feeling about the speediness of the justice. So normally it takes ages to have a judgment, and it's very expensive. But on the other way around, just for this reason, what I'm experiencing in the US, I would like to know if the speech that you gave also takes into account the US experience, because there I'm experiencing an IP litigation, very complex, that it has been based on an agreement written and signed more than 30 years ago, that is a couple of centuries in software domain, and where the plaintiff is basically using the litigation as a strategy, to make money, to squeeze money, so the so-called troll opportunistic behavior. And while and perhaps as per the European parameters, this litigation would have already been dismissed. In the US, we have a very sensitive judge to IP matters, so this means that we have been engaged in a very long and very expensive fight where we are spending a lot of money. So I'm really questioning, the question to you is, Richard, first of all, is this presentation applicable also to the US landscape? And second, what do you suggest to defend ourselves against this troll opportunistic behavior?
The big problem in the United States is the cost, particularly of the discovery stage of the proceedings, and this is relatively common as well in our industry, that people get a patent or an intellectual property right. Doesn't have to be a particularly good one, and they assert it, and the defendant knows that it is going to cost him 1 or 2 million just to get through the discovery stage. But the troll demands a sum of money which is comparable to the cost of defending. And the business decision, the sensible business decision at that point is to pay. The problem with that is that then you become known as a soft touch, a soft target. In our industry, BlackBerry has become known as a soft target. And so immediately then everybody, all of the other trolls, all of the people who are waiting, pounce on them because they see that someone has paid. And in a way, you have to resist it, you have to fight it and defend it. There are a couple of changes in the US that are helping a lot around the area of costs. Traditionally, it was just assumed that you would never recover your costs if you won in litigation. Just over Christmas, or just before Christmas, we were sued. We took a case through to trial against a patent troll called Acacia. Acacia was asserting patents against us in the Eastern District of Texas, which is, the absolute paradise for the patentee. Acacia lost, and we got an award of costs against them. So that now means that Acacia is a serious disincentive to try that trick again, because they now have to pay our costs for litigation. this is becoming more common, particularly if the case is unmeritorious, that you can seek costs awards against your opponent. And that, I think, will reduce the future of troll litigation in the US. It doesn't help with the cases that are already ongoing.
Mm-hmm. Which is not the case, I think, as per the New York law, because our case is based on the New York law, and I have been told by our specialist that you cannot be, even if it's absolutely absurd litigation and you win it, you cannot get a refund of at least in part of your legal costs.
Okay, that seems to be a trend that's changing. I don't know about that particular one,
Yeah.
but we found it moving.
So, and thank you very much, Richard. And Kirit, regarding India, so my experience is that it has been, we were been talking about this matter before when we were waiting for this session, is that it's very difficult to find, in my experience at least in India, first of all, as you also said, a speed justice also in this case, and you know, whenever the case turns into a criminal one, to have a police specialized really in IP crimes that is able to support you. And sometimes our position has been converted into from a plaintiff, someone that is claiming something, into the investigated one. So what are your tips to be given whenever we have to face a similar case in India nowadays?
You're right. You have to strategize and have a proper team in place because, again, it depends on the volume and the stakes. The police is a double-edged the department. Not many of them are aware of how IPR really works, although I must say now in the last 5-10 years they've been sanitized, and cyber cells have also come up in terms of cyber crimes. That's on the rise. In terms of retail products, a lot of them are now being given education, having workshops. I would advise that the companies, which are large multinationals especially, should basically have a process where they educate the government, statutory authorities time to time, and work along with them rather than complaining how the system is. It's a large country. There are issues, but the systems do work if you manage it efficiently, and I don't mean in any wrong methods, but it does work if you have a good team and you do a thorough due diligence much prior and in hand. It's a team approach which you need to take forward, basically. And mostly when you have institute criminal proceedings, the other side does come around and settle the matter.
Okay, thank you.
In the last year, Ericsson has had 2 cases in India against Intex and against Micromax, both Indian companies.
Yes.
And in both cases, Ericsson prevailed. The Indian courts made what I've read from reading them are very sensible decisions, where they've looked at US case law, they've looked at UK case law, and they've really considered it very carefully. And I was surprised that a foreign company asserting patents against an Indian company in an Indian court was so successful with such well-written judgments.
No, the courts in Delhi and Mumbai are very well versed with IP laws, and they're pretty protective about the ownership. It's not necessary just because it's a foreign company. It depends on the facts and the merits of the case. And a lot of times, foreign judgments are used as a guiding principle.
Okay, interesting. So, guys, I don't know if any of the colleagues here has any question you would like to ask. So, what we learn is that there has been. I just took note of one of your sentences saying that a patent very expensive, the patents fail, so that you have to file 3 patents to get one really protected. So what is, in your opinion, again, an alternative way to protect the IPRs instead of starting a long process for the patent, and then face a long fight whenever you think that your patent has been violated by someone else? Is there any alternative to this traditional, let's call it, method?
We have tried recently an arbitration with both Samsung and with LG. Rather than get involved in this massive multi-jurisdictional 3-year-long 70, 80, 90 patent dispute, both Samsung and LG have agreed to arbitrations where we don't go patent by patent, country by country, trying to look at both sides, thousands of patents. We accept that both sides has a patent portfolio of a particular that has some value, and then start looking at comparables and see, okay, what did Samsung get when licensing its patents to various other people? What did Nokia get when licensing its patents to various other people? And start to try and deal with the dispute on a portfolio basis, rather than going patent by patent, country by country. That has worked well. Because the real dispute between the parties is not whether this particular patent in this particular country is valid or infringed, it's how much do I have to pay for a license to your patents. And the arbitration it was expensive, it was long, but it was much, much cheaper, quicker and less painful than litigating patent by patent, country by country. And that seems to be the future. We've done that with Samsung, we're doing it with LG, Ericsson started doing it with Huawei, but they managed to reach a settlement. What it needs is both sides to agree. And there are some people who simply will not agree. Apple, for example, will fight tooth and nail. And some of the Chinese players will too. But gradually, as this becomes more accepted, then courts start to push people towards it and start saying, why are you litigating? Why don't you go into an arbitration and solve the real dispute, which is how much, not this peripheral fight that you're having to try and pressure each other to the negotiating table.
Okay, and I also heard about mini trial. Have you heard about it? So it's a sort, in the US, it's a sort of arbitration, not binding for the parties, where the binding put on the table the issues and try to narrow the claims so that you go to court not with, as sometimes happen, 1,000 different claims, but you really narrow what is the subject matter that needs the help of the judge to be evaluated and to then give as an output a judgment.
It's a good idea, and I suppose it's a form of mediation, isn't it?
Exactly.
Where you both sides try to cut away the fat in the other's dispute. And we haven't tried it. It's probably something we should look at.
Okay. Thank you so much.